Hello and welcome to the Minimum Competence episode for Friday, June 12th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, SCOTUS shuts down Saba's ICA private suit, narrows judicial estoppel in bankruptcy, and tosses Abouammo's obstruction conviction on venue. Let's remember, it is better that 10 guilty persons escape than one bad pun get a laugh. And read today's legal news. On this day in legal history in 1967, the Supreme Court handed down a unanimous opinion in Loving v. Virginia, striking down Virginia's Racial Integrity Act of 1924, and with it, the anti-miscegenation statutes that 16 states still had on the books. Chief Justice Earl Warren wrote for the court. The case had come up from a county courthouse in Caroline County, Virginia, where Richard Loving, a white bricklayer, and Mildred Jeter, a black and Native American woman, had been arrested in their bedroom in the middle of the night in 1958 by a sheriff acting on an anonymous tip. They had been married in the District of Columbia and returned home to Virginia, where their marriage was a felony. The Lovings pleaded guilty, accepted suspended sentences on the condition that they leave the state for 25 years, and lived in exile in Washington until Mildred wrote a letter to Attorney General Robert Kennedy that landed eventually with the ACLU, which took the case. The Supreme Court's opinion did two things at once. It held that Virginia's statute violated the Equal Protection Clause because it drew on an explicit racial classification with no legitimate state purpose beyond preserving white supremacy. The court used the phrase the Virginia statute itself had used, and it held that statute violated the Due Process Clause because the freedom to marry is, quote, one of the vital personal rights essential to the orderly pursuit of happiness by free men. That second holding, the marriage as fundamental right strand, is the through line that runs from Loving to Zablocki v. Redhale in 1974, to Turner v. Safley in 1987, to Obergefell v. Hodges in 2015. Every one of those decisions cites Loving and treats it as the foundational case. Whether the court's substantive due process marriage doctrine survives the next decade is, as we discussed earlier this week, one of the open questions in American constitutional law. But Loving itself remains intact, and on June 12th of 1967, the court said something it had not said cleanly before, that the right to marry is the kind of liberty interest the Constitution actually protects. The Supreme Court on Thursday reversed the Second Circuit in FS Credit Opportunities Corp. v. Saba Capital Master Fund Limited, holding 6-3 that the Investment Company Act of 1940 does not give private parties a cause of action to seek rescission of fund bylaws or other contractual terms. Justice Amy Coney Barrett wrote for the majority. The dispute came out of a campaign by Boaz Weinstein's Saba Capital against 11 closed-end funds that, under Maryland's Control Share Acquisition Act, had adopted bylaws limiting the voting power of any shareholder who accumulated a disproportionate stake without the consent of other shareholders. Saba sued under Section 47B of the ICA, which makes contracts that violate the act unenforceable, and the Second Circuit held that Section 47B implied a private right to rescind the bylaws. The court told the Second Circuit to look harder at the modern implied cause of action doctrine, which since Alexander v. Sandoval in 2001 has been hostile to inferring private rights of action that Congress did not write into the statute. The opinion reads as a continuation of that line. The ICA's enforcement structure is committed to the SEC, not to private plaintiffs, and Section 47B is a defense against contracts the SEC has already determined to be unlawful, not an offensive cause of action. The dissent by Justice Sotomayor, joined by Justices Kagan and Jackson, argued that this is a misreading of Section 47B's text and that the majority is gratuitously narrowing the enforcement of the federal securities laws. The practical impact is significant. Activist investors who had been pushing closed-end funds to convert to open-end form or to alter investment strategies lose a federal court tool that they had been using. The funds themselves and their independent directors gain a meaningful structural defense. Expect the next round of activist campaigns to move to state court fiduciary duty theories instead. The court on Thursday also decided Keithley v. Buddy Ayers Construction, Inc., vacating the Fifth Circuit 9-0 in an opinion by Justice Ketanji Brown Jackson. The case is small in its facts and large in its doctrine. Thomas Keithley filed a Chapter 13 bankruptcy in 2019 and failed to disclose on his schedule of assets a personal injury claim he later brought against a construction company over a truck accident. The Fifth Circuit barred the personal injury suit on judicial estoppel grounds, the long-standing equitable doctrine that prevents a party from taking one position in one proceeding and a contradictory position in another, using a three-factor test under which a debtor's mere knowledge of the facts plus a motive to conceal was enough to bar the later claim. The Supreme Court said no. To determine whether the omission was inadvertent or mistaken for judicial estoppel purposes, the court held the lower courts must look to the totality of the circumstances, not just to whether the debtor knew of the facts and had a motive. The doctrinal interest of the case lies in two concurrences. Justice Sotomayor, concurring, wrote that judicial estoppel should likely never apply in an open bankruptcy case at all. The trustee can simply amend the schedule and pursue the claim for the estate, which solves the problem judicial estoppel was invented to address. Justice Thomas, joined by Justice Gorsuch, went further and questioned whether federal courts have any inherent authority to apply judicial estoppel as a freestanding doctrine, period. a position that, if it ever gets 5 votes, would unwind a doctrine that has been part of American practice since the 1850s. None of that is the holding, but the votes to revisit one of the duller corners of equitable estoppel are now visibly on the table. The third unanimous decision of the day was Abouammo v. United States, in which the court reversed the Ninth Circuit and vacated the obstruction of an FBI investigation conviction of Ahmed Abouammo, a former Twitter employee whose underlying case was one of the more striking Saudi Arabia infiltration prosecutions of the last decade. Justice Elena Kagan wrote the opinion. The facts are simple and the constitutional point cleaner than the facts. Abouammo, while working at Twitter's San Francisco office in 2014 and 2015, accessed and passed on confidential user information about Saudi dissidents to a Saudi official in exchange for a $42,000 watch and $200,000 in wire transfers. The FBI eventually came to interview him at his home in Seattle, where he had moved by 2018, and during those interviews, he created and emailed agents a fake invoice intended to make the wire transfers look like a legitimate consulting fee. The Justice Department charged the obstruction count along with foreign agent and wire fraud counts in the Northern District of California, and a San Francisco jury convicted him on all of them. The Supreme Court held that the obstruction count belonged to the Western District of Washington, not California, because the act of creating and sending the false invoice, the only act that supported the obstruction charge, happened entirely in Seattle. Article 3's venue clause and the Sixth Amendment's vicinage requirement together do not let the government try a defendant in a state where no element of the charged offense occurred, no matter how convenient the prosecution. The obstruction conviction is vacated. The foreign agent and wire fraud convictions, which had different venue facts and were not before the court, stand. Abouammo will not walk free, but the prosecution will need to decide whether to retry the obstruction count in Seattle, and the case is now a clean precedent that the venue clause has real teeth in a multi-district federal investigation. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. If you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcast. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday. And until then, remember, if Plan A doesn't work, remember, there are 25 more letters in the alphabet.